All right, let's go ahead and get started. Hello, everyone, and thank you for joining our webinar titled The 50 Shades of Privacy, the case of leveraging ISO 27701, also known as your Privacy Information Management System, PIMS. This webinar is hosted by SGS and Dayspring Technologies. I'm going to go ahead and introduce our guest speakers today. We'll start with you, Drew.
Thank you, Katie. Hello, everyone. My name is Drew Kirby. I'm a data privacy technology and compliance consultant with Dayspring Technology. Basically, anything that has to do with technology applications or compliance standards that we're going to talk about today, from state-level compliances to CCPA, to healthcare and HIPAA, FDA, MHRA compliance systems, in particular, ISO programs 27001 and 27701. Just some quick background about me. Historically, technology and regulatory. Prior to consulting, I was in healthcare and pharma for about 20 years. Ran a quality and technology department for contract manufacturing. So I've seen kind of all sides of the auditing table, from being in front of the FDA to the DEA to any regulatory agency you can imagine, as well as internal audits and external audits for our customers and clients. So happy to be part of the presentation today. Thank you to everybody who's attending, and SGS and Katie and Willie. I'll turn it over to Willie for his introduction.
Thank
you very much. My name is Willie Fabricius. I'm the Global Head for Strategy and Business Development here at SGS in the knowledge business stream. So knowledge at SGS is responsible for third-party certification, training, and the like. I'm in the industry for the last, 25 years. I was exposed to ISO way back, started implementing an ISO 9002 system, so that dates me a little bit, at a stamping facility in Germany. Then I joined one of the world's largest certification bodies, joined them for 3 years in Johannesburg, South Africa, and then 7 years in the States. Went to another CB for 15 years, and then since September last year, I'm with SGS. Educational-wise, my background is computer science, so obviously information security and privacy is in my portfolio of responsibilities. Back to you, Katie.
Thanks, Willie. And my name is Katie Warlick. I'm the Business Development Manager for Information Security for North America. So anybody that has any inquiries regarding information security or privacy, feel free to reach out to me. I have been in the industry for about 10 years and have had the opportunity to work with both Drew and Willie in previous lives. So excited to be presenting with both of you today. Thank you. All right, so here we go. So to give you a quick overview of SGS, from the beginning in 1878 as a grain inspection house, SGS has grown to be the world's #1 leader in testing, inspection, and certification services across a variety of sectors, including healthcare, medical device, industrial, food, transportation, and a number of additional industries. Today, we are present in 140 countries, serving clients every day from our 96,000 employee workforce. SGS, we also offer training services and have a link towards the end of our presentation to talk to you about our SGS Academy in this slide deck. All right, Drew, passing this to you.
Thank you, Katie. We have not been around since 1878, so I'll be honest with that. But we've been in business, Dayspring Technology has been in business for over 13 years. We're a team of technology, privacy, and regulatory experts that get together with our clients to meet and support departmental and corporate goals designed to support, again, management systems, compliance programs, validation efforts. We do focus on fit for purpose design, so we're not typically sending in a team of 20 engineers or developers to throw policies and compliance at you. We want to understand the business and the business goals, because even though compliance may impact, may start in one department, it does impact all business. So key to us is learning the business and the process, so we can implement these solutions, some of the things we're talking about today, for the corporate need as well as the department and compliance need. Talk a little bit about our engagements. Obviously, we're focusing today heavy on data privacy and compliance systems, but you can see here we have an array of activities that we support, both from compliance systems and management systems in healthcare and in business and finance, auditing of systems, building, improving these processes, or even doing gap assessments to understand where the value or where the business needs to step up from again a privacy or quality or security design. There's a lot of cross function there. I mean, we typically focus on technology departments or privacy departments or compliance, but it does impact all parts of the business, as I mentioned earlier. So when we talk about who we serve, it is all levels of business and all levels of markets. Just because it's technology, it could be a technology in the healthcare industry, vendor management throughout the process. You can see some of the industries we do business in and have done business in, from life sciences to Fortune 500 companies to a top 5 commercial insurance carrier building their compliance systems, whether it's ISO or data privacy, as well as like leaders in financial planning software building their risk management programs, or numerous ISO programs and down to auditing pieces. So a little bit about our business to give you some background. Happy to have partnership here with ABS to present to you. My main goal today is to give you some background on data privacy and kind of lead into some of Willie's things. So I've given you background already on myself. I'm going to skip over this slide and kind of take you into the meat of the presentation here. So the goal today, at least from my end, is to give you a kind of overview of privacy laws, both US and abroad, and kind of the acronyms here, or the alphabet soup of the privacy laws that are out there. So I think with our catchy title of 50 Shades of Privacy, I'm supposed to tie in a 50 Shades joke, but I couldn't think of one that was not above PG. So we'll leave that to the imagination, and just know that if variety is the spice of life, there's certainly a variety of privacy laws that are out there. So I'd like to take you through kind of an overview of some of them, how they impact both the customer and the business. So this may be a refresher for some, hopefully a general overview for others, and then an in-depth thought of some of the needs of the business as we go through the processes. So, of course, data privacy is nothing new. Certainly, it's been around since information security in general have been in place. So there are many industry requirements for healthcare privacy, HIPAA privacy laws to protect personal information or healthcare information. The financial industry has some of their own privacy laws, state-level privacy laws, but it's really been the last 5 years in both the US and abroad where we've seen these privacy laws go into place and actually be advocates for the consumer and give the consumer rights. So again, my goal today is not to cover every aspect of these privacy laws, but to give you an overview or a recap of what's in place now and certainly the requirements behind them, certainly from a data side or from a customer rights aspect. So kind of jump around a little bit of a timeline, but hopefully anybody that's doing business in California is familiar with, at least heard of, and or compliant to the CCPA back in 2018. This is the kind of first on the books state law. So at this point in time, there's not any federal law, a single point of comprehensive federal law for consumer advocacy. CCPA went into effect in 2018 and became enforceable in January of 2020. So I'm going to take you through this and kind of get you through the timelines up until present day. So the meat of this law is now that businesses actually have fines and requirements if they don't meet those. Fines if they don't meet those requirements. So to give you an example, when it became enforceable in July of 2020, there had been major breaches in the past, and I like to use the example of Equifax, which was about 5 years ago. Excuse me. In 2017, Equifax had a major breach. 140 some million customers' privacy data was exposed. About 14 to 15 million of that subset of data was California consumers. Now, this happened to be a year before CCPA was put in place, but to give you an example of the magnitude of that and again, the teeth to some of these privacy laws is, had CCPA been in place prior to that Equifax breach, Equifax could have on the hook for $11 billion in fines. Now, that's a very large example, and they ended up paying, I think it's like $400 million in a settlement because CCPA wasn't law. But there are other examples of that. Facebook with Cambridge Analytics that impacted 24 million users. Fast forward to 2021, big Zoom data breaches. there were class action lawsuits. So it didn't actually fall under CCPA penalty, although it certainly aligned to CCPA. There were class action lawsuits that resulted in $85 million in damages. So this is, you're starting to see over the last couple of years, not only enforcement of privacy laws, but customers, consumers get their privacy rights back. And if they're not getting the rights back, companies are held accountable. So that's the general purpose of this from that end, from the consumer end, is understanding what the impact is. So right now we're talking about California residents. We'll continue to expand throughout the US and the globe as well. So there are certain rights for consumers under CCPA and eventually the CPRA law, which I'll talk about. So I'm going to go over kind of high level a few of these rights to give you some background or just kind of reinforce some of the knowledge. So under CCPA, there's a request to know, and that a consumer can make a request to a business in California. What type of personal information do you have? If Drew Kirby makes a request, what information do you have on file for me? Where was that information collected? Think about it as a business, through websites, through online applications, paper applications. Not only that, but why the information is collected. What type of information? What are the categories of that data? If I'm submitting for a policy or a loan, the expectation is that information is going to be used for that. But in reality, as we know, businesses use that for a lot of other things, whether it's marketing or working with third parties. These right to know, or the CCPA laws and the right to know requirement under the consumer data privacy laws now hold the businesses accountable for these. So the business need to know where this data is going in a clear fashion so they can respond to these consumer requests. I like to use the example sporting events. So I'm in Philadelphia and I'm a big Flyers fan. If you know anything about Philadelphia and the hockey team recently, there's not a whole lot to be proud of. But anyway, as I go into the stadium, as I've done for years, once I sign my ticket or I hand them my phone, once I get past the week or daily swag of t-shirts, the first thing I do is get accosted with signing up for a credit card or signing up for one of the bank systems or filling my name out for someone to come out and assess my windows. All these are data inputs that certainly under the California law gets tracked by customers or by companies because they need to understand where this data is coming from. I can use the same example of my daughter that we just dropped off in college. It wasn't a few minutes before she got on campus that people were offering her credit cards, filling out of personal information. So not just my name and phone number, but date of births. In some cases, you're applying for credit cards, social security number. So think about a business that collects that data and where that data goes. You're inputting personal information. It's getting processed through whatever the input device is, whether it's an iPad or a computer system, or in some cases even paper. Now we have paper with personal information on it. To web servers, to database servers, probably customer relationship databases, financials, to be able to pay. If I'm signing up for something, it's now in another system. So the connection of those systems and the structure and data is very important to be able to comply with any of these privacy laws, in this case, CCPA. Not to mention third parties. And if I'm sharing this data with a third party, or in some cases selling this data to a third party, or if I've outsourced my billing and now the transaction that I was having with one customer now is sent to another third party. Those are all things to consider and be aware of as we talk about the rights the consumer has and where data goes within a business. So continuing on the kind of the rights of the consumer path under CCPA, another right is the right to delete. And I will say, not going too far in detail with all these pieces, there are a lot of exemptions for some of these things. So you think about the business obligations or legal obligations. A customer has the ability under CCPA to request the right to delete or request the deletion of their information. But in a lot of cases, customers don't have to comply to that. They need to be able to fulfill that request, know where the data is, so they can correctly comply to it. So again, if I have a contract with, I'm looking for insurance and I'm looking for a loan and I'm submitting this information, the understanding is I have an agreement with the business. In most cases, that data will be exempt or not deleted because it's need to be kept for purposes. But thinking back to that structure, where the data is stored, where it goes, is it on premise? Is it in the cloud? Am I using a third-party vendor, a SaaS vendor to provide a solution, and where that data lineage path goes? So you kind of see and hear a theme here as far as data management goes. So the last right I'll talk about kind of at a high level again for CCPA is the right to opt out. And this has changed a little bit over time, but the right to opt out of sale of personal information. Again, the definition has changed a little bit to sale and sharing of information. But think about it again, as a customer, if I'm California and I'm submitting information to a website, I have the expectation that I'm submitting it to a company for certain purposes. Under CCPA and the other privacy laws, the information needs to be disclosed to me of why they're collecting this information. And I have the right to opt out of the sale of information or sharing of information at this point in time. But really, a lot of our customers from the sale of information, unless their business is collecting and reselling data, a lot of them have moved or stated that they're not actively selling customer information. They're there for a contract with their customer, right? Whatever that is, whether it's a loan, a policy, financial advisory, whatever the process is, that's their key focus. Yes, they want to collect this data, but they need to inform the customer and give them the rights to opt out. And certainly the sale of information. You can see there's a few other stipulations here with minors and other pieces and some exemptions. A lot of this comes into play with cookies, right? Is when data is being collected unbeknownst to a customer. So a lot of people are looking to give the opt out or the management of cookies to make sure they're not selling or sharing that data that they unknowingly, in many cases, gave the customer. And then again, marketing, right? Marketing is a big piece of this sale or sharing of information. So again, where that data goes once it's submitted. So more about the rights and requirements under CPA. There are more things about CCPA that we talk about, but this is kind of a high-level piece of the law that was put in effect in 2018. Kind of fast forwarding a little bit to 2020, as CCPA was getting put in place, CPRA, the California Privacy Rights Act, was being developed and put in. It's basically not a change to it, but an amendment to it. So it doesn't replace CCPA, but it enhances it. In many cases, it defines language, as I mentioned, about the sharing and selling of data. In other cases, it left a few more questions open. But again, it's an enforceable law. It's in place and effective, and it'll become enforceable at the end of this year. So if customers and clients haven't considered already CCPA from 2018, we now have another law on top of that amends that law that you should be aware of, and as far as where data goes. And I'll take you through some of the nuances and updates to that. I think one of the key things here, besides again the enforceability at the end of this year and the beginning of next year, is the creating of an agency. Back to that consumer right advocacy. There's an agency that used to be the Attorney General that enforced this, and now they're creating an agency. So those fines I was talking about, there's actual customer advocates that can help support the customers in claims and actually go after these businesses that are not following or violating CCPA and now CPRA. So talking a little bit more about CPRA, I'm not going to go into every section of it, but you can see some of the rights are similar to what we've talked about before, and some of it expanded. So again, amendments to the process, clarity in some areas, expansion of rights, so the correcting of personal information. So we think about the correcting of personal information submitting to a business. It seems pretty straightforward and common that a business would want to have the correct information on file. So if it's a web application or an online application, there are ways most likely for a customer to update basic demographic information. But under CPRA, there's a requirement to be able to intake that request and update that information. So again, think about standard business practices in the financial industry or insurance industry. You want them to be able to update this, but you need to give them that mechanism to do that. But also there are, of course, exemptions. So legal or business requirements. So we can't go in, if I'm applying for a loan, you can't go in and update your credit history, right? Or can't request to delete your credit history. There are exceptions to that. But the underlying theme, again, is the topic of data inventory and data management. Because there are instances where you need to honor customers, particularly businesses in California, need to honor these. And they need to have clear cut guidelines of what they're honoring, what they are responding to, and what they're providing the consumer as far as these requests. So a couple other pieces on here about the limit of disclosure and sensitivity, and some of these actually mirror some of the international laws as well. Data minimization, data retention. So use the example of the college application or the hockey scenario that I used earlier, where I'm going in and filling out something, right? Whether it's a credit card or banking information. What is the nature of that data? How long is it being kept for? So if I have a policy or an agreement or a service with someone, the expectation is I'm collecting that data for that purpose. Well, now it needs to be clearly defined. What if I didn't sign up for that service? What if I just applied for that service, but I didn't commit to it? What if I was denied information? How long is that business going to keep that information? Or if I had a contract with that business, again, whether it's a loan or insurance or some type of personal information that was collected on my behalf to do business with that company, but my business has ended, the term has expired or whatever, what is their obligation? Now they will say there's business obligations and maybe legal obligations, but what is that point in time that says how long they need to keep that data? Is my data available to them forever? So part of what CPRA does is businesses need to disclose that information to customers on what they're collecting, again, why are they collecting it, and the reduction of information. Not just collect any data point that I need, but why they're actually collecting that data to help limit the use of that data and the disclosure of data. Again, to conduct business, but to also support customer privacy rights. So to further expand on the retention piece, I think about backup systems and building security and privacy by design. So whether the system whether the data is housed on site or in the cloud, you think about replication data and backup data. All those types of data need to be considered in this data process, because while production systems have a lot of security and policies around them and hopefully privacy concerns, we now need to take into consideration this replicated data or this backup data, because it does have personal information, and under these privacy laws, businesses need to be aware of this data, how is it housed, and how they can fulfill consumer requests and make sure the data is disclosed properly, or in some cases deleted properly. One of the last scenarios I'd like to highlight on this is with data is test systems, because we see it a lot. We go into businesses and do evaluations or assessments or work towards compliance programs, and it is by no means best practice, but it does happen all the time for businesses to take their production systems and make copies of that data, that structure, and build it into a test system or development system. And the response we get is, well, we're scrubbing that consumer data as we go. Well, that needs to be part of the policy and practice in order to fulfill privacy requirements, privacy laws, because now we've created other space for personal information that may not have the same protection and policies and procedures around production data. So something else for businesses to think about as we talk about privacy data and privacy rights. The last couple are dealing further with third parties, as I talked about earlier, where that data goes, right, from one system to another. Does it go to third-party third-party providers? Again, maybe it's cloud systems, so whether it's private cloud or public cloud, you're putting it in AWS or Azure. Yes, businesses have outsourced a lot of that risk, or some of that risk, from a maybe security perspective or a redundancy perspective, but they've opened up a lot of other risks that need to be managed and maintained, not just from a security perspective, but from a privacy perspective, right? If you're contracting with a SaaS provider, do they have access to that data? So auditing and reviewing your third parties, and certainly your third-party agreements with service suppliers about what happens if there's a data breach. How is this handled? How is the main business notified if they're outsourcing data, right? So things to think about and be aware of from under CPRA requirements. The last bullet I have on there is dark patterns. So it's noted in some of the discussions. It's not necessarily official, kind of in a draft provision, but it does mirror some of the international laws as well for ease of use of language. So privacy is a right of consumers. It shouldn't be any more complex for a consumer to have privacy to their data, again, in the context of the business that they're trying to work with or need to work with. So it talks a lot about, again, draft provisions about ease of use of language. It shouldn't take a customer any more time to give themselves greater privacy protection of their data than others. Similar to companies can't pay customers for collected data unless it tells them that. It can't give advantages to one set of customers that it collects more data from than others without full disclosure of that information. So again, an underlying theme of protecting consumer privacy rights, but it all goes to an understanding of privacy law and where the data is. Beyond just the database teams, the application teams, the privacy teams, it affects all aspects of the business. Anytime a change is made to an application or a website, these privacy laws need to be, everybody needs to be aware of these privacy laws and the impact that it can have on customer data. So kind of closing out California, I can expand a little bit on, I said the last 5 years, and you can see as we get through more acronyms, not going to go through every individual one, but there's additional 4 other states in the US that have privacy laws. And not a federal law in place yet, but Virginia, Colorado, Utah, and Massachusetts have state privacy laws now on the books and working towards enforcement with a lot of the similar, not the exact same parameters, but a lot of the similar privacy rights. You can see Colorado talks about data privacy agreements, similar to some of the European language, with understanding back to third parties, who is dealing with the data. Talk a little bit about controllers and processors, who's managing the data versus who owns the data, who has access to the data, again, under privacy law. So just kind of closing out on the US, I did use the International Association of Privacy Professionals. They do a good job of state privacy tracking as well as international. So there's a link in the presentation here to their website, not just the map that shows you kind of the status of them, but if you go to the link and you scroll down, there's actually a table view that gives you each state, what status of compliance they're in, and how they may align or differ in practices. So a good resource as we get into talking about privacy compliance. And I would be remiss if I didn't talk about the potential federal, U.S. Federal Privacy Act. So American Data Privacy and Protection Act has been something that's been talked about in one way, shape, or form for several years. Prior to the last election, I think we generally said in 2020 that maybe 2 years after the election, the U.S. would look to have a more formulation of a federal privacy law. Well, we are past 2 years now. There is one act that has actually just as of July gone through committee vote. So it has the potential to go to the House floor. It does have a lot of the similarities that we've talked about in some of the state laws, and I'll talk about even in the international laws. But the idea, again, is that protecting consumer rights, levying fines or punishments to organizations that are not managing the data, managing personal information and consumer data, and fulfilling the rights that consumer request. And of course, there are exemptions to this. There will be maybe planned enforcement by the FTC as part of this. But as I said, to this date, it's not in place yet. It has passed committee vote. I believe it's the Energy and Commerce Committee that actually submitted it, passed that vote. But when you do the research on it and review a lot of the officials that have signed off or voted for this privacy law, they all agree, or most of them agree, that in its current state, it will not get passed. And they would not vote for it again. So like any bill or law that comes to place, there will be time on this. And even then, it won't exempt or won't overtake California law. So there's a lot of different privacy laws that customers and businesses need to be aware of, is kind of the summary of that slide. So I'm going to close out and kind of going backwards a little bit. We started in the US, but I'm going to now international law. So anybody that does business internationally hopefully should be aware, certainly in Europe and the EU, about the GDPR, which is the General Data Protection Regulation. So similar to CCPA, it was certainly groundbreaking. Prior to that, as GDPR was being adopted, CCPA was in draft, and then you can see enforceable in 2018. But also groundbreaking at the time, giving customers and citizens of the EU privacy rights against businesses. And you can see there's 7 principles defined in there. I won't go through every one, but the same kind of meat behind, their teeth behind the privacy laws of the US. There are fines levied for violations of those. So a good example of that is the H&M clothing line. In US dollars, I think it was like a $40-some million fine based on lack of access control, based on lack of data minimization practices. British Airways, the same thing. To give you other examples of affected 400,000 customers, their personal information data was exposed, and it was found due to lack of security and lack of privacy policies in compliance with GDPR. So at $26 US, it equates to. But again, just showing again, there's teeth in these privacy laws and reasons for businesses not only to be aware of them, but to show compliance and demonstrate compliance to them. So that, I'm not going to go into every one, but you can see GDPR kind of high level. DSAR, or data subject requests, so consumer requests or rights that they have under GDPR law, similar to CCPA compliance, right? So if you look at them, the right to access was one we already reviewed. Informed notification, the right to rectification is the right to update. Similar, but not exactly the same. So when we talk about privacy law and privacy standards, is how do businesses comply with these? Not only can they submit to a consumer request, right, but how do they know that they have the correct data? And that's really where kind of the privacy laws tend to align. So to recap everything we talked about, from the various acronyms of current US privacy laws to international laws such as GDPR, yes, the focus is on consumer rights, right? And the ability for a customer to submit or to ask privacy or protect their privacy, right? It really puts privacy in their hands, or the ability to privacy in their hands. And it's enforceable by outside agencies, by government agencies, to levy fines, to push for compliance, and basically work companies into compliance that aren't already in compliance. But in the background, all of these laws have some commonalities surrounding data security, privacy structure. What does it look like to businesses on the back end? I mentioned the examples I used as far as bringing personal information in the system, the multiple system to go to. Data inventory and data lineage is very important to these practices, so that if you get a consumer request to delete or know their information, you can either honor that request or know why you're not honoring that request. It shouldn't be a guessing game or going through a practice each time to understand what data is subjected to these rights under the various privacy laws. And again, third parties, we use a definition here of controllers and processors of data. So, who actually owns the data? If I'm working with third parties, am I managing the data? Am I sending data to a processing facility that's managing that data? So all things to consider as we talk about the various privacy laws. And so one of the things we talk about is there a single solution or a solution that can help us manage all these privacy laws. And with that, I thank you for your time. I'm going to turn it over to Willie, who's going to talk about maybe a potential solution to help manage some of these data processes and data inventory practices.
Yeah, Drew, thank you very much. Very good overview. And well, coming back to the title of this webinar, 50 Shades of Privacy, right? So there are at least 50 states, or there are 50 states in the United States. And sooner or later, we will see legislations in all of those states. Maybe, maybe not. Maybe we will see it on the federal level. But as you pointed already, Drew, we see it definitely on a global level. So how are organizations actually managing all this frameworks? And that's the big challenge, right? So in order to answer that question, I would like to first introduce to the audience ISO, the International Organization for Standardization. And now you may say, just along, you say ISO, but then you say International Organization for Standardization, so it doesn't make sense, right? So it actually does make sense, because ISO is actually a word, and stems from the Greek word isos, which means equal, like isobar, those lines on the map that indicate the air pressure in the weather forecast. So the International Organization for Standardization is actually an association, for lack of a better word, a group of international standards bodies coming from different countries. So for example, Germany is represented by DIN, the Deutsche Institut für Normung. The United States is represented by our friends from ANSI, or the American National Standards Institute. And so each country has their representation at those ISO committees and work groups that are discussing the next version of standards. So for example, this year, at the beginning of this year, ISO 27002 was updated and has been published as the result of a very lengthy international collaboration between those standards bodies. And very soon, we expect ISO 27001 being updated. So the FDIS, the final draft international standard, has been already circulated. So that means ISO 27001 will be updated most likely still this year in Q4. And that is the real power of ISO, because representatives from all countries are coming together. Just to show you what I mean with all countries, um, technically it might be not all countries, but when you look at the map of the world, the majority of countries are actually represented, with some um, exceptions for whatever reason. But generically speaking, ISO is the body that creates very well-known international standards for all kinds of things, whether this is management systems for quality, management systems for environmental management systems, or in our case now, management systems for an information security management system or privacy management system. So what are some of those standards that are noteworthy in this context? There's obviously ISO 27001. The most recent version is 2013 with an amendment later on. But as I already mentioned just a couple of seconds ago, this standard will be updated in due course, still this year, most likely in Q4. We will see a 2022 edition of the standard that will incorporate all those changes that are coming from the release of ISO 27002, which has been updated this year. But in the context of privacy management systems, I really would like to emphasize ISO 27701, or technically speaking, it's ISO IEC 27701 edition 2019. And this is a document obviously published by ISO together with IEC, but is an extension to ISO 27001 with additional guidance and requirements to manage privacy requirements an organization may have. But then there's also ISO 22301, which is a standard for business continuity management system. But then there are also derided standards and documents out there. So for example, there is from the CSA, the Cloud Security Alliance, a document or certification actually, that is focused on cloud security, but is based on ISO 27001. And the same is true for TISAX, which is a German car industry-based assessment that is focusing on information within the automotive supply chain based on ISO 27001. So here we see a wonderful examples of the power of ISO standards. They are recognized globally because they are representing globally recognized best practices for the protection of information, for the protection of privacy information in particular. So when we are talking about those standards, we are also talking about certification. And certification could be done by an independent certification body like, for example, SGS, that is going in and assesses the implementation and the effective implementation of the management system, ensuring that the requirements of the applicable standard have been indeed implemented properly and effectively. Once this has been confirmed by the auditors, they will submit an audit report for independent review, and if everything is perfect and is according to the rules, then a certificate can be issued. Here we see an example, or should I say 4 examples of SGS certificates for the various different standards, and this is just an example. So what is ISO IEC 27701? Well, the standard was published in August 2019, and it provides both requirements as well as guidances for the implementation and maintenance of a privacy information management system. And that's pretty interesting because usually those ISO management system standards are divided into 2 documents, one for guidance, one for requirements. But in this particular case, ISO decided to merge both guidance and requirements into one document. And that is very important to note because once an organization is going to the journey of implementing a PIMS, they really need to make sure that they understand what the requirements are versus what the guidelines are. Please also note that the upcoming ISO IEC 27001-2022 will have a revised title, and this revised title includes, among others, cybersecurity and privacy protection. And that really emphasizes that information security is part of privacy information system and vice versa. We cannot separate information security and privacy information security. Those are just simply interlinked. So bear with me one sec. I'm a little bit confused about my own presentation. 27701 is an extension to ISO 27001, and that is also a very important statement. And that really means that an organization cannot be certified to ISO 27701 by itself. There's always the requirement to be also certified to 27001, and only then an organization can be getting certified to 27701 as well. Now, don't get me wrong, this certification of against the two standards can be done concurrently, but there cannot be any 27701 certificate without an underlying 27001 cert. It goes so far that there are very specific requirements in the applicable ISO documents that govern us as the certification body, and that is addressed quite prominently in applicable standards. It also goes so far that the certificate for 27701, the validity of that certificate cannot exceed the validity of the 27001 cert. So if an organization is getting certified first to 27001, for example, and then a year later to 27701, that 27701 cert will only be valid for the remainder of the duration of the validity of the 27001 certificate. So the standard addresses both controllers as well as processors. So organizations who are in control of the PII, as well as those organizations who are processing the PII. The standard also includes mappings to other documents, namely to GDPR, as well as ISO IEC 29100 and ISO IEC 27018 and ISO IEC 29151. But let me be very clear. Certification to 27701 does not mean certification to GDPR according to Article 42 or 43 of GDPR. Reason being is ISO 27701 is a management system. So that means we, SGS, are accredited to ISO 17021, which governs how we are doing our processes, how we are conducting those assessments, ensuring that we are independent in our assessments, making sure that we are not combining, consulting and certification, because that is definitely an unacceptable approach and will not be tolerated. But that 17021 that governs us is not the standard that is being mentioned in GDPR Article 42, 43. There, GDPR mentions 17065, which is, for lack of a better word, product, process, and service certification, which is different than management system certification. So therefore, by definition, a certification to 27701 cannot be fulfilling the requirements of Article 42, 43 of GDPR. That said, we are definitely aware of some kind of developments on the European level to address this situation. And sooner or later, we do expect that there will be indeed certification regimes out there to address this. So the structure of 27701 is very standard. What a surprise for a standard, right? So there is obviously the need for terms and definitions so that we do know what does it mean, controller versus processor. Then there are PIMS specific requirements related to ISO IEC 27001 and PIMS specific guidances related to ISO IEC 27002. And then there are additional guidance for PII controllers and PII processors. And then there are the normative annexes, the things I mentioned already earlier, the PIM-specific reference control objectives and controls for the controllers, respectively the processors. And then there are also informative annexes, which are, well, just for information purposes. And these are the things I mentioned earlier, the mappings to other external documents. So in summary, ISO 27701 is an extension to ISO IEC 27001 for the management of privacy management systems. ISO IEC 27701 also contains both requirements and guidances, and ISO IEC 27701 can be used by an organization that are both controllers and processors, and contains an annex to the standard of GDPR. Now, the mapping to the GDPR actually then triggered a very important project. And this project is actually headed and open sourced by Microsoft, which is called the Mapping Project. The Mapping Project is, as I said, an open sourced tool that is available to everyone and anyone on GitHub. And here the QR code will lead you directly to the GitHub repository, where volunteers from around the world are contributing to map ISO IEC 27701 requirements to whatever regulation is out there. So if you are wondering, well, I'm doing business in Singapore and the Singaporean privacy requirement is applicable to us, how can 27701 help me? No problem. The mapping project will be able to help and support you in finding the answer to that. Or you say, well, I'm doing business in California, so therefore, obviously, I fulfill already the California requirements. How does this help me with the requirements to fulfill the, I don't know, Brazilian privacy regulations? No big deal. That mapping project can help you. So feel free to visit this, use this QR code with your cell phone and investigate further how that mapping project potentially could help you. That said, I would like to hand it over to Katie.
Thanks, Willie. All right, so what you're looking at right here is what a certification process looks like. So if you are interested in being certified to ISO 27001 or ISO 27701, or really any standard, the first thing that you'll do is you'll contact myself, and we will be sending off this presentation, and you'll have all the contact information and additional resource links as well. But you would contact me so that I could provide you with a questionnaire to collect all the scoping information needed and to provide you with a quote. From there, you're going to want to look at the competencies of your organization and see if you have any gaps in skills. SGS does have a training academy, so we can provide you with any training assistance. We are an independent certification body, and so we are not able to consult at all, but we do have a training academy that can provide to you different types of training like requirements, implementation, internal audit, lead auditor training, things like that. We always recommend, your next step being a gap assessment. So this is not a requirement, but prior to going into your stage 1 and stage 2 audits, it's always good to have a gap assessment where an auditor comes on site and does a review of the management system, just to make sure there's no major gaps or roadblocks going into the stage 1 audit, which is the first part of your initial certification, which is followed by the stage 2. That's confirmation that the management system is fully implemented. From there, if everything works out, you'll receive your certificate. And then once you receive your certificate is good for 3 years. There is ongoing improvement. So you do have a regular surveillance audit annually, and every 3rd year is a recertification audit. So those are kind of just the basic process steps of certification. All right. You could do it. Okay. All All right, so apply what I have learned today. So next week, take a look at the ISO 27001 standard, review the content of ISO 27701, check out the regulatory mapping tool, which again will be provided to you. Here's a link to the tool as well. And then if you have any additional inquiries, reach out to SGS. I'm happy to talk about any of our training courses or even just initial discussions on what your organization needs to do to be certified to ISO 27001 or PIMS. Within 3 months of the presentation, it's a good idea, if this is something that you are looking to move forward with, to go ahead and we pop on to our SGS Academy and check out our public auditing courses. You always want to make sure that you have an in-house auditor trained to complete your internal audit prior to going into your stage 1 and stage 2 assessments. Always recommended to book that pre-assessment, and within 6 months, you should go ahead and book your audits. Upcoming webinars. So this webinar will be available on demand. Last week, we had global webinars introducing ISO FDIS 27001. That is available on demand as well. Our upcoming webinar next is on medical device information security. So that's going to be September 22nd. This is also seen in the resources widget. And then for October, we're going to be doing a webinar on vendor management. So you can register to any of these webinars online, just as you registered for this one. And you can also go ahead and go back and check out our on-demand webinars. All of these are recorded. And with that, I want to thank everybody for attending the webinar today. Thank you, Drew and Willie. You guys were fantastic. And I'm just going to hop into some questions. We've got a few minutes. So Drew and Willie, be ready. We've got a couple here for you. Willie, the first one I'm going to give to you. So the question is, with the ISO 27001 and ISO 27002 standard being updated, how does that affect audits to ISO 27701? And then just to combine some questions, there was a follow-up in there that asked about the integration of the two. So if they're not doing a standalone 27701, if they want to go ahead and just integrate them both at the same time, how does the updated 27001 standard affect that?
Very good question, actually. It doesn't really affect. and this is one of those things that is on a regular basis surprising for a lot of people. A, 27001 edition 2022 has not been published yet. B, there's always a transition period. And we know from the IAF, the International Accreditation Forum, that right now we are looking at a transition period of 3 years after the publication of the standard. So for all intents and purposes, for the next couple of months, there will be no change. Furthermore, and I think this is even more important, when you look at ISO IEC 27001, the old version as well as the future version of the standard, it starts with a very simple premise question. Who are we? What are we doing? What is the context of the organization? What is the kind of information we are actually processing? What are the risks associated with that kind of information with regard to confidentiality, integrity, availability? And once we have identified those risks, we need to find out what could be potentially compensating controls. Once we have identified those controls to mitigate the risk, then we need to verify whether the Annex A controls are indeed applicable or not applicable. And that needs to be documented in what is called the statement of applicability. So whether there is a change in the Annex A or not is really not important at that stage, because the organization has already identified the controls that are suitable to mitigate the identified risks. Now, do we expect that organizations are reviewing the risk assessment and the statement of applicability once the standard has been updated and published? Absolutely. But as I said, there will be a transition period of 3 years that allows an organization or all the organizations transition from the old to the new version of the standard. With regard to the integration of 27701, yes, it goes without saying that with within due course, we do expect that ISO 27701 also will be updated to reflect the new controls in the Annex A, respectively the controls in ISO 27002. But for the time being, don't worry, just go ahead and implement to the best of your knowledge. The changes, the updates will be relatively minute and will not lead to any delays whatsoever. I hope this answers the question. Back to you, Katie.
Nope, that was great. Thanks. Okay, and so this question, I think this is good for both Willie and Drew, for both of you to answer, as one of you is from a certification body and the other is from consulting. But are you seeing an increase of companies implementing and or certifying to ISO 27701? And I think what they mean by implementing is, are companies just becoming compliant internally to 27701? Or are we seeing them starting to certify to the standard itself? So Drew, I will start with you. What are you seeing in your line of business with companies?
The first part, right? Certainly to the alignment perspective, as part of that process, as we talk through all the CCPA and CPRA guidance, looking for that kind of level setting ground, what Willie reviewed with the controllers and processors. It's not, ISO 27701 is not going to make them compliant to these standards, but going to give them all the background information. So we're seeing more and more compliance to 27701. And then from Willie, from the certification, I'll let you answer kind of that end of things.
Sure. I know that some companies claim to be compliant to whatever, but going back to the last 25 plus years of being in the third-party certification business, I can tell you, even those companies who think that they are compliant are not necessarily compliant. That's the power of third-party assessments and certification. On a regular basis, even with the best companies, we discover small little issues here and there, and that's okay. At the end of the day, that's the power of ISO standards, because they are talking about continuous improvement. They are talking about corrective actions. They are talking about management reviews and internal audits. So things will happen, and that's the power of continuously improving, right? But just saying, trust me, I'm compliant. Well, trust me, I brushed my teeth this morning. How do you know that? Trust me, I'm a nice guy, right? Trust me, I wash my hands when I get out of the bathroom. Trust me, I'm compliant to that, yeah. Right? Yeah, but exactly, yeah. Trust but verify. At the end of the day, the value of a certificate is exactly that. An independent third party goes in, assesses against the requirements, and if the requirements are indeed fulfilled, then a certificate is getting issued. Otherwise, there is no certificate. Yeah. So, just my 2 cents.
And I can even provide a little input to that question too, just as somebody who focuses on sales and business with customers. You know, last year there were a lot of inquiries for ISO 27701, and people were planning to move forward with the certification process. And this year, people are actually starting to go through the certification process. So I definitely have seen a pretty decent increase in those inquiries. All right, let me see. What else? Okay, and then what happens when privacy laws are amended or new federal state data privacy laws get approved?
Yeah, so that's, I'll take that to start, really, feel free to chime in, but that's the beauty of 27701 compliance, is that it's that structure and background. Yes, privacy laws are going to change, and there's difference between the privacy laws, but 27701 gives the governance structure that Willie was talking about, that gives you compliance on the back end for your data privacies. There'll always be little nuances that change as the privacy laws come up, but having compliance to the structure and key is a key piece to that, I would say.
Yes.
And I think with that, we're up on the hour. Oh, sorry, Willie.
And you know, let's face it, there's a very, very important requirement in ISO 27001 that says, and I paraphrase, that the organization needs to have a suitable process, effective process to identify applicable regulatory requirements. So That means if there is indeed a change, the organization must have a process that is also able to identify those changes and thus implement those changes into the management system.
The reciprocal of that is the privacy law says there needs to be a security and privacy compliance structure. So they're pointing to each other in that case. Right.
Yeah. All right, well, we'll wrap this up. Thank you, everyone, for attending the presentation. Again, if you have any questions, feel free to reach out to me, and I'll make sure I'll direct you to the right point of contact. And have a wonderful rest of your day.
Great. Thanks, everyone.
Thank you. Bye-bye.